Good day, Internet. This is Chavez and Valko LLP, the key to your immigration solutions. I'm Senior Associate Benjamin Hamilton. With me, as always, is Associate Attorney Andrew Craven. And when you see our smiling faces, we are here to talk about all things employment based immigration. Andrew, what are we talking about today?
So today we're going to talk about the EB-1C immigrant visa. This is essentially the way to get uh, managers and executives permanently transferred into the U.S. So it's similar to the L1A for temporarily transferring executives and managers.
So, we do have a series of videos on non-immigrant work visas. Go check those out. This is a continuation of our series on essentially green card categories for employment. Um, and again, as Andrew noted, the EB-1C has a lot of similarities with the L1A visa. So if you have the L1A and you're wondering what your residency options are, well, then this is the place to be. If you're an L1B, this may not be the best option for you. And we're going to talk about that a little bit more in detail. But let's start. Oh, so um, we commonly refer to these green card categories as EB 1, 2, 3, 4. Just so you know, EB is employment based, and it's the first preference category, second preference category, third preference. So that's the lingo. So that's why you hear EB 1 through 5. And it turns out that EB 1 has a couple of subcategories, hence the EB-1C. So, Andrew, what is the EB-1C immigrant category?
So like I was saying earlier, it's a immigrant visa petition that allows multinational companies to transfer multinational managers or executives to the US. And as you noted earlier, very similar to the L1A, but different from the L in the sense of there's not that specialized knowledge group. There's no L1B version of this.
So, if you are a straight L1B, you're likely going to have to pursue a different route, which is the perm labor certification that we'll address in full in a different video. But there's also the possibility that someone does have an L1B, but they may also qualify as an L1A. So even though they have an L1B, that person still might be able to use the EB-1C if their employment abroad and employment in the US would support, right, the managerial argument. So you're not categorically barred from using this if you're an L1B, right? If you can make that argument. But anyway, so we're talking about intercompany transferees. What is that?
So, an intercompany transferee means an individual who, within 3 years preceding the date that they file the immigrant petition, they've been employed abroad by a qualifying entity that seeks to have them enter the U.S. to render those same sort of managerial or executive duties.
So, what if this person is already here on an L1?
So in that case, what USCIS will actually do is look at the 3 years prior to their entry under the L1 visa, but they also have to have the same company that employed them previously be the company that they came here to work for and be the company that is now petitioning for the immigrant visa.
The idea is it's 1 year in the last three, right? You have to prove that you worked as a manager abroad. And so if the person is not currently in the US working for the company, they're going to look at 1 year in the last three from the date of filing. But if the person has been in the US already working for the company, like they're an L1A, right? I mean, they could, Andrew, what's the max you can be on here on an L1A?
7 years.
Yeah, so hypothetically, this person could have already been here 5 years on an L1A. So if we look back one in the last three, well, they've been in the US the entire time. That's why that one in the last three is from the date of entry, not the date of the application. But that only counts is if you're in the US working for that company. We've had cases where someone was here like on a student visa, right? And then we were looking at the one in the last three. And in that case, they weren't here in a status to work for the company, for the organization. It was something unrelated. So it's still one in three from the time they applied. And we've had cases where they missed that 1 in 3 criteria by a matter of like a month. Because again, whether or not you're in the U.S. working impacts if it's 1 in 3 from entry or 1 in 3 from filing. So what is a qualifying organization?
So, a qualifying organization means that the U.S. and foreign company share common ownership or control, such as affiliates or subsidiaries.
So what is a subsidiary?
So, a subsidiary just means a legal entity which the parent owns directly or indirectly more than half of the entity that it controls.
So the key here is like more than half. This is why a lot of people, when you talk about L1s, you hear about 51% as sort of like the standard. It should be 50. Now, there are some exceptions there with joint ventures and stuff, but in general, you want to see at least 51% just to be safe. I mean, legally, it's 50 plus a fraction, so I guess it could be like 50.001 and qualify. But 51 is the standard number. What about an affiliate?
So, an affiliate means one of two subsidiaries, both of which are owned and controlled by the same parent company, or one or two of two legal entities owned and controlled by the same group of individuals, such as individual owning and controlling approximately the same share or proportion of each entity.
Yeah, so the difference here is one is like the foreign company owns the U.S. company, or vice versa, or in this context, we're talking about the same individual owns both companies. If there is no majority owner, like let's say there's 4 people and they own the foreign company in equal parts, 25-25, then it needs to be the same in the US organization. So you can't be like, well, hey, me and my 3 brothers each own 25% in the foreign company, but hey, our one brother, we decided to cut him out, and just me and my 2 brothers own, my brothers Daryl and my other brother Daryl, right? We all own it. That typically won't work, right? Because it's too different. Right. So typically, if there is no majority owner, you want to see sort of the exact same owners and percentages, or at least close, right? I mean, again, if you had 4 owners and it was exactly 25 in each, but like in the US company, there was the same 4 owners, but like, I don't know, one was 24 and one was 26, that would probably be fine. Um, so I would say the majority of cases we see tend to either be a parent subsidiary or affiliates with the same majority owner. Those tend to be the most common. Obviously, we do see some where there is no majority owner, um, but there's some other kind of key points to throw out here that distinguishes the EB-1C from the L1A, right? Because in the L1A context, the foreign or the U.S. company could be a branch office, right? So, for example, the U.S. company could be a branch office of the foreign company, which a lot of times means that's actually not something that's been formally incorporated in the United States. That's typically not allowed under an EB-1C. So you could have a setup that works for L1A but doesn't work for EB-1C. Specifically, if you have a U.S. company and the foreign office is a branch, that's fine for EB-1C. What they don't like is that it's a foreign company that has the U.S. office as a branch. That's what they don't like. They're also not big on sole proprietorships in the U.S. So again, kind of some key differences between the L1A and the EB-1C regarding the qualifying organization. Basically, for EB-1C purposes, you want an incorporated U.S. company. I mean, just period. Just that's how we want it to be set up, so we don't have any issues. Now, the entities have to be doing business in the United States. I mean, that sounds fairly straightforward. Both companies, the company abroad and the company here, actually have to like have employees and clients and be generating revenue. Are there any exceptions to the doing business rule in the EB-1C context?
No, so this is like we've been talking about another key difference between the L1A and the EB1C is that there is no new office exception for the EB1C. You have to have actively been doing business prior to filing this petition.
Yeah, so in the L1A context, you can come in and say, hey, I've set up this company, but it's not operating yet, but here's our great business plan. Give me a year, and then I'll go in and get it all up and running, and then I'll come back and extend, right? You can do that in the L1A under a new office L. There is no new office exception. Actually, the regs specifically state that the U.S. company has to have been doing business for at least a year. So that's why usually when people are talking to us about a new office L, and they're like, okay, I get the visa, but how quickly can I file for residency? It's usually like, get the new office L, it's a year. We file the extension, and when the extension's approved, then we'll talk about residency, right? We'll talk about the EB-1C. But you can't go straight into an EB-1C if the U.S. company hasn't been doing business for at least a year. So we're going to break down a little bit more the 1 year within the last 3 qualifying employment, because obviously this is the crux of any L1 or EB-1C application. So employed abroad for 1 year within the last 3. What do they mean by abroad?
So abroad just means exactly what it sounds like. So the individual has to have been physically employed outside of the US for 1 year within the last 3. Abroad applies to anywhere physically outside of the US, not just the person's home country. So, if you're, say, Spanish, working in England, like, it still works.
Yeah, a common one we see, like a lot of engineers, they're from wherever and they're like working in Dubai or somewhere in the Middle East or Qatar, right? And saying, "What? Who cares? Abroad is abroad." It doesn't have to be in your home country. Um, and again, we've already kind of talked a little bit about the 1 year in the last 3, right? They're either going to look at from 3 years back from the time of application, or 3 years back from the time of your entry to the United States, depending on whether or not you entered to work for the company already as an L. What is, obviously one of the ways we document the 1 year and last 3?
So best evidence is just 1 full year of pay stubs, but you can also use HR records, formal letters from the HR department that state when the person started working and the other key details about their employment.
Yeah. So think of a letter literally on company letterhead from the HR. It says, hey, this person started on this date in this position. You can list out the job duties. Obviously, we get together the pay stubs. Now, obviously, this can be a little bit trickier because we deal with a lot of like smaller to mid-sized companies where the person we're talking about is the owner of the company and may not have pay stubs. And it's hilarious how you get this request for evidence from USCIS that says, well, we want the person's pay stubs. And we're like, we've already explained to you. they're the owner of the company, which has been clearly documented, and they receive profits and dividends. They don't have pay stubs. In those cases, obviously, you still try to get a letter from HR. You try to, obviously, you're documenting their ownership. I mean, depending on how they declare their taxes and stuff, you could even potentially get tax returns, depending on how they report those profits and dividends and whatnot. So moving into the sort of key area of discussion, right, which is how does USCIS define a manager and executive? Because when it really boils down, we do see requests for evidence about ownership and about 1 year in the last 3, but the main thing you see requests for evidence that they're going to hit you on is, are you a manager or are you an executive? And believe me, just calling yourself one does not qualify. USCIS has their own very specific definitions of these terms. And the number one thing that you have to understand is that they love to bury their head in the sand and play ignorant. They want you to spoon feed them all of the details. So you can say, I'm the owner of the company. I have 100 employees. Like, yeah, but what do you do? What do you mean, what do I do? I run the company. No, but what do you do on a daily basis? I don't know. I have meetings and phone. I mean, look, this is how it plays out. It can be really frustrating where you're like, why do I have to write this like 30-page job description for the owner of the company? This is ridiculous, but it's how it works out. Anyway, also, when we're talking about managers and executives, the definitions here are actually the same for L's. So here there's like a direct sort of one-to-one correlation between the two. So how do we define a manager?
So managerial capacity has to have meet these 4 criteria. So first, they have to manage the organization or department, subdivision, or some component of the organization. Two, they have to supervise and control the work of other supervisory, professional, or managerial employees. And they have to manage an essential function within the organization or department subdivision of the organization. Three, they have to have the authority to hire, fire, or recommend those, uh, recommend hiring or firing for other personnel actions for other employees or directly that they directly supervise. If no other employee is directly supervised, uh, at the senior level of the organizational hierarchy or with respect to the functional manager. And then finally, they have to exercise discretion over the day to day operations of the activity or function for which the employee has the authority.
So this is a lot. These four criteria you have to go through. A couple things to keep in mind. Three key pieces of evidence: organizational chart. It needs to have the name and then the name and title of every employee that's in the beneficiary sort of department or under their direct supervision. You want to have very detailed job descriptions, and you want to have an employee list. That's kind of where you take that org chart and now put it into a list form where you can provide more information. So that's not just the name and title, but also the job description for the subordinates, the education level for the subordinates, and even the pay level for the subordinates. Anyway, we're looking at this couple key components, right? They need to manage, a key component of the organization, the whole organization, a function, a department, but they have to manage something, right? They need to supervise and control the work of other supervisory or professional employees. Or we're going to talk about an exception to that called the functional manager, right? Has the authority to hire or fire or other HR things, and then exercise discretion. One of the key things to look at here is you can't be what's called a first line supervisor. So let's just say, hey, I'm a manager of the McDonald's. They're going to say, great, I have no doubt that you manage, 20 people, but it's probably not going to qualify because they're going to consider you a first line supervisor, meaning you directly supervise the employees and they're not professionals, right? So if you have a two-tiered structure where you directly supervise the employees, then those employees need to be professionals, just period. So we've done cases where, they had 5 employees, but they were all engineers, right? Great. You only supervise 5 employees. They're all engineers. It qualifies. The alternative is to have like a 3-tiered structure where I, as a manager, supervise the supervisors or lower level managers who supervise the employees, right? So you think of 2-tiered structure, they're professionals, 3-tiered structures. Then the people I'm supervising are not the line employees, but it's actually the mid-level supervisors and managers. And again, coming back to, not only do you have to prove that you're a manager, but if you're claiming it's a 3-tiered structure and I'm supervising supervisors, you have to prove that the supervisors are in fact supervisors, right? And so that's like, you need their job description. And it gets to be really onerous sometimes. So we talked about one of the exceptions, which is a functional manager. Andrew, how does that work?
So basically, you can be a functional manager if you manage a clearly defined and essential function of the organization. Uh, you must function at a senior level within the organization and exercise discretion over the function. And really, what this is, if you're, say, the head of an entire department, but no one necessarily directly reports to you, really finding a way to work around, having to do a 3-tiered structure or show that reports are professional.
Yeah, so think of like a mid-sized company, and you're like the HR manager. Obviously, a big company, if you're an HR manager, you're going to have subordinates, right? You're gonna have all these HR specialists and stuff. But think of like a mid-sized company or a smaller company where you're the HR manager, but you don't have any direct people that report to you, but you're clearly operate at a high level within the organization. You direct a major function of the organization, right? You would qualify as a manager. This could be like a finance manager and stuff, or something similar to that, right? So these are it is possible to get an L1A or an EB-1C approved for somebody who may not necessarily have a ton of direct reports if we can claim they're a functional manager. But one of the sort of key, what is one of the other sort of key points about a functional manager?
So the functional manager cannot perform the function themselves. There must be employees within the organization or a third party contractor that performs kind of these lower level day to day duties of that function so that they relieve the functional manager from performing what's called non qualifying duties. So essentially, kind of your low level admin versus high level decision making.
Yeah, so you're like, "Hey, I'm the HR manager, but, we do use a third-party service, like, I don't know, ADP or something, or Workday, and, we have an external, accountant who handles our payroll," so that there still are these other parties involved that relieve this person from performing the sort of day-to-day stuff. If you're claiming you're an HR manager, you're probably not going to want to say, well, I'm literally doing the payroll for the company. It's like, no, no, no. Like that's actually being done by a third party provider. Which frees me as the HR manager to focus on my managerial duties, right? So you always want to show that there are still people that are relieving them from doing the sort of mundane day-to-day tasks related to that function. Same thing if you had someone who was like a finance manager or like a CFO, you want to be, well, no, we actually have a third party like accountant who's like actually entering the numbers into the books. Um, so that is a sort of a key distinction. Another key thing here, this is about managers in general, but especially functional managers, is can you claim someone's a manager or a functional manager and that part of the employees that they manage or the employees that support their position are located outside the US?
Yeah, so currently, case law does state that immigration has to consider employees through the wider organization as long as it can be demonstrated that they directly support the U.S. position and U.S. operations. So the subordinates don't necessarily have to be in any specific location.
If you're interested, just Google matter of ZA. Matter of ZA. It'll come right up and you'll see the case and some memos from USCIS. Now, one of the more issues we run into is trying to get USCIS to follow their own freaking guidance because they love to just ignore stuff. You really have to beat them over the head with it, but it's pretty clear case law where it makes sense, right? Because you could say, well, I have a restaurant in Mexico and I have a restaurant here. I mean, those are kind of two separate things, and I don't think your chef over there is going to be, cooking meals over here. Those are kind of separate things. I mean, maybe you have some overlap with like someone you hired in Mexico that does your marketing and accounting, right? That you could say, well, this person actually does support the US company and we're kind of including them in sort of the US org chart. But we do have a lot of companies that, for example, they're like app developers. And so all their developers are in Eastern Europe. And even some of their like marketing people, and then over here, they just have salespeople. And then to say, look, well, if I'm the CEO of this organization, I mean, they all report to me, they all support me, even though the developers are in Eastern Europe. This is one organization that works together. And that's logical and it makes sense. And in that case, USCIS, according to case law, has to consider those employees as part of the org chart. So, we do see a lot of cases in which, the actual number of physical employees in the United States isn't that much or that many. They also have to consider like contractors and stuff too. So if you're looking at someone who's involved in construction or trucking, where there's naturally a lot of contractors, they have to consider those too. Um, Another important thing we're going to move on to executives, but one thing I want to throw out there: do not mix and match. We see people that look at the four duties of a manager and the four duties of an executive, like, well, I like those two, and I like those two. Can I just No, USCIS hates it, right? Do not try to mix executive and manager. Pick one and run with it, right? Pick manager or pick executive and go with it. Do not try to mishmash the duties. They will call you out on it. They hate it. Anyway, how do we define an executive?
So an executive has four criteria. So one, they have to direct the management of the organization or a major component or function of the organization. Two, they have to establish the goals and policies of the organization, component, or function. Three, they have to exercise wide latitude in discretionary decision making. And finally, four, They can receive only general supervision or direction from higher level executives like the board of directors or stockholders of the organization.
I mean, the idea is showing that the organization is here. The big difference between an executive and a manager is, an executive is at a higher level, right? So they're not focused on necessarily like a department or a function. They're focused more on the wider organization. So you really kind of have to show that there is sort of sufficient size and staff to sort of support this argument. But it can be really frustrating because USCIS can come back and be like, well, prove to us that they exercise wide latitude and discretionary decision making. And you're like, he owns the company. What do you mean? Why should I have to prove this to you? I did prove to you that he owned the company. So therefore, by its very nature, he exercises complete discretion. He does whatever he wants. He owns the company. But you still have to prove it. So you're like, okay, well, I'll go get a letter from the HR. But I mean, it's one of these things that's like, how do I prove that? So a lot of times you'll find stuff like, well, here's their lease. He signed it. There's this big contract. He signed it. And so you can kind of sometimes show, well, he's signing all this stuff, right? I mean, so clearly he's actually, same thing with receives only general supervision or direction from higher level executives. Obviously, that makes sense when you're talking about a big company. If you're doing this for like Microsoft, you could have someone who's an executive, but then still has someone above him, a CEO, a board of directors. Of course, in our experience, we're dealing a lot with companies where it is the owner. And they're saying, well, prove to us that he receives only general supervision. What are you talking about? He receives no supervision. He owns the company. So you find sometimes you're trying to argue points that you're kind of like, how how do I argue this other than I proved to you he owns the company? um, and you'd be surprised about how frustrating it can be. Again, we're going to maybe discuss this a little bit more detail. So, how do we prove that someone's a manager or an executive?
So typically, we would start with a detailed organizational chart and a detailed job description, and then kind of go from there. Like you're saying, it can be a difficult thing to prove sometimes, but at least with the organizational chart, you can visually show where they fall, who they super, or which department they supervise, and how many levels are above them.
So, and again, even if you have an organizational chart, right, and they see, oh, this person has subordinates, they're always going to assume the worst. They're going to assume you're guilty until proven innocent. Guilty meaning, well, yes, he does have subordinates, but how do we know he's not a first line supervisor? So that's why it's like, well, you start with the org chart, but you got to work down from there. Okay, well, let me get detailed job descriptions and information about all of his subordinates, right? What's their job description? What's their education level? What's their pay level? For all it becomes very onerous, but you kind of have to do it. Obviously, if this person supervises like 100 people, then you would only really focus on all that detailed information for sort of the top tier under that person, not like everybody down the chain. Because if there's like 300 people that report to them, and at the bottom is like a janitor, you don't really have to worry about the janitor. You worry about the direct reports, and then job descriptions. Couple of things. Most anybody is going to have some duties that are non-managerial, and that's fine, right? What we're trying to prove here is that they dedicate a majority of their time to their managerial duties. So one of the things they always ask for are they want a very detailed job description, and they want to know the percentage of time spent on each duty, because that allows them to determine whether or not you're actually spending a majority of your time on your managerial duties. Now, it's hilarious that we'll do this and they'll still ignore it. They'll come back and be like, well, we didn't like these three duties. And it's like, dude, you asked me for percentages. I gave you percentages. Those three duties that you don't like only account for 10% of his time. They literally had this happen. You're like, you guys can't even do basic math. Because even if I concede to you that those three duties are not managerial, they're only 10% of his time. That means he spends 90% of his time on managerial duties. What? So again, job description on its own, not enough. You have to do percentages of time. And another thing they commonly ask for and we commonly give is we give them like sort of like the general job description. Hey, here's the 15 things he does, right? And detailed, right? Can't just list like you don't want just a bullet point. You want a bullet point and then with like a little paragraph below it, like 2 or 3 sentences to kind of give some more context or detail to it, including what employees that they work through or utilize to perform that task. But a lot of times we give them a daily job description. They ask for it a lot of times. Right? We say, okay, now let's break this down into what their actual day looks like. Sometimes that can be awkward because I know in our case, our days are all over the place, right? It's just based on what I need to do today. Do I have some consultation? Do I need to work on a certain case? But anyway, a lot of times you can give them a daily job description. And it's hilarious because a lot of times the daily job descriptions for an executive is like meeting, 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 phone call, meeting, emails, meeting, meeting. It's like, what are you expecting to see here? Like, is he going to put like, yeah, I was working on the floor selling product. I mean, you want this daily job description, but it mostly involves meetings. And so again, it's details, details, details. Do not assume anything because they will not. They will bury their head in the ground. They have to be spoon-fed everything. It has to all be laid out in detail, right? Or they'll just play dumb and issue a request for evidence. And a lot of times the request for evidence will ignore stuff you actually did submit and then request stuff you did submit. Don't get angry. I mean, we do, but you write your initial request for evidence response to be very harsh, right? And you go back and reread it, like, okay, I'll tone it down a little bit.
Take a walk,
Anyway.
a deep breath.
Yeah, you got to write the initial response and then like sleep on it and then come back, because your initial response is like, dude, you asked me for 15 things. I sent you all of them. What's going on here? But they work off a boilerplate RFE or request for evidence. So it's not them being like ignorant. It's them being more kind of lazy. Anyway, moving on from the most important part, then whether or not you're a manager or executive, to some other parts. What is it that they require from the actual beneficiary themselves, other than proving the 1 in 3 years? What else do they require from the beneficiary?
So they also have to show their prior education, training, and employment, and show that it qualifies them for the intended position that they're going to work in the U.S. That doesn't necessarily have to be the same job as abroad, as long as both positions qualify.
Throw out, yeah. So they are within their rights to say, you didn't provide any evidence that this person's really qualified for the job. We want to see resumes and educational documents. And so you always want to include that. Another thing I want to throw out here, just kind of at random, is it is possible that, let's say you were an L1A, or say that you were a manager abroad and that you came over on an L1B, because the position they actually offered you in the US is a specialized knowledge and not a managerial. So in the L context, they don't have to match, right? You can be an L1, you can be a manager abroad, specialized knowledge here, and that's fine, right? And when you're doing an EB-1C, the L is for the current position we want the person to be in, but an EB-1C can actually be for a future position, right? A position that they will enter into when they get the green card. So it is possible someone was a manager abroad, but we brought them on an L1B because their current position is specialized knowledge. But the actual position we're offering pursuant to the EB-1C is a managerial position, right? So current position's L1B, but the EB-1C is based on a future offer of a managerial position. You can do that, right? So it can get a little complex. Obviously, reach out to us so we can take a look at your case and kind of figure out how to make this work for you. The main benefits of going the EB-1C route is obviously you get to skip the whole labor certification process. So that can be a really good thing. The labor certification process that the L1Bs get pushed into, that the H1Bs get pushed into, you get to skip all of that if we can make the L1A work. And look, at the end of the day, the EB-1C doesn't work. We can still go the perm labor certification route also. So let's talk about the process. What form am I filing?
So in this case, you're filing just an I-140 with all of the supporting docs. You get to skip the labor certification like you're talking about.
What is the current filing fee for an I-140?
The current filing fee is $700, but I believe in the Build Back Better bill, is that the one where they're talking about raising the fees?
Yes, dramatically. Like massive increases to all the fees, which is a whole other story of, wait, you're saying that your agency is funded by fees. So if you're saying you don't have if you don't have enough money, I mean, if you're getting more cases, you're also getting more money. So that means, anyway, it's a whole thing of like, so apparently whatever you're charging, You're currently charging $410 to issue a work authorization card, but that's not enough, even though you've admitted that it only takes you 12 minutes to process the case. And whatever. Very mismanaged organization. Let's just put it that way. And they apparently need more money per case. So, a couple of things, right? Obviously, that I-140 is prepared by the employer. In the EB-1C context, you can't self-petition as an individual, right? You need an employer to petition. Now, of course, you could be the owner of that company, but you need an employer. The I-140, again, comes from the employer. It's not something that you self-petition in the EB-1C category. Again, if you're the owner, you kind of are in a roundabout way. Can you premium process so premium processing is available for I-140s, but not every category. Is it available for an EB-1C?
Currently, no. EB-1C is one of the few categories where premium processing is not available currently. This is another thing that is subject to change and supposed to at some point.
Hey, Andrew, let's have another rant here. So in October 2020, Congress doubled the premium processing fee from $1,225 to $2,500. They doubled it. And as part of that, Congress told the agency that they needed to expand premium processing to other places where it's not currently available. The problem is that Congress kind of just said do it, but didn't tell them when to do it. So USCIS was more than happy on day one to charge double. Year later, no expansion. So you just got double the money. What did you do with it? We thought you were going to get double the money and use it to hire more officers to then expand it to I-539s, I-765s, to EB-1Cs, right? To EB-2 national interest waivers. Did they double the fee? Yeah, day one. Have they expanded it? No. Cool. So now you're raking in double the money. What are you doing with it? And because it's still taking you 12 months to issue a work authorization card, which again, you've admitted in court takes you 12 minutes. And pre-Trump was taking you 60 to 90 days. So yeah, I don't know what they're doing with that additional money. So there's no premium processing available currently for EB-1C, although technically Congress told USCIS they're kind of supposed to do it. When that's going to happen, we don't know. Here's another key question. If I file an I-140 and is approved, does the I-140 confer on me any immediate immigration benefit?
No. So essentially, once you get an approved I-140 in any of these categories, you get almost nothing. But it is the legs for an adjustment of status case. So at that point, once you have the approved I-140, you can start applying for a green card.
Exactly. So the I-140 is kind of that first step that makes you eligible to then apply for residency, right? Because you need that sponsorship, right? So people do it through family by filing an I-130 or through employment by filing an I-140. Now, just so you know, there are certain people that would be eligible to file both of those, the I-140 and the I-45, at the same time, right? So there's certain cases in which we do the I-140 first. Once it's approved, then we do the I-45. And if you're Indian doing a perm, unfortunately, you file the I-140, wait 15 years, and then file your I-45, which is ridiculous. But there are cases in which we can do both at the same time. So in general, in the EB-1C category, in most cases, you are eligible to do them at the same time. Andrew, what is one of the reasons that we might not, though?
I think the biggest one is just the risk associated with the I-140. So something to keep in mind with USCIS, I mean, as you've talked about with these RFEs where they ask for items they've already sent, there's just no guarantees. So a big reason to wait is to kind of make sure that your I-140 is approved. You don't lose any extra fees to USCIS or legal fees, and then you can move forward and file once it's approved.
So the I-140 is filed by the company on behalf of the employee. The family's not really involved, right? And the I-140 is the most difficult thing to get approved. It is kind of like if you're climbing up this immigration hill, right? The I-140 is kind of the peak. And then after that, it's more just bureaucratic nonsense, but it's not really that as difficult, right? So when You file the I-45 though, you file those, each member of your family has to file their own and pay a separate fee, which is $12.25 per person. So if you have a family of 4, again, if you have smaller kids, it can actually be a little bit less. But let's say you have a family of 4 and you're all paying the full fee, you're talking about $5,000 in filing fees to file for residency. So if you file the I-140 by itself and it gets denied, you just lose that. You can actually try again. There's nothing prohibiting you from refiling the I-140 or appealing it and fighting it in court. But if I file the I-140 and the 45 together, right, I'm now putting out those $5,000 in filing fees. And if they deny the I-140, they'll also deny the I-45. So it's more of like a financial risk in terms of filing together. So if you come to us and say, well, my employer's paying for everything, then you're like, okay, whatever. If you want to do them together, we'll do them together because it's not really a risk to you. It's the company that's going to lose money. Or if someone comes to us and says, I'm an executive at Microsoft, we're like, well, that's a low risk case, right? So let's just do it all together. But you have someone to come to us that it's like, hey, I have a small business abroad. I came and opened up here. It's a small business. I have 1 or 2 employees. And then we're kind of like, that's a pretty big risk to file the I-140 or 45 at the same time. You might want to separate them. But what's another reason we might actually file them at the same time that would push us to concurrently file the I-140 and I-45?
I mean, I'm not really sure which specific reason you're thinking of. There's a couple. In some cases, it could be if you're running out of time in your current visa status and you need the employment authorization that comes with it. Um, that would be one of the bigger ones.
Definitely nailed one of them. There's one more.
Trying to think. Running out of time, need the work authorization,
I think
or
we
if
stumped him.
there's any other reason, really, just for the timing. I
It
know
is a
if
timing
you're
issue. So obviously with L's, they have a 7-year cap, right? And if the employer delayed filing the I-140 to like where I'm like, oh, I only have 6 months left on my L, like, and I'm done because it's the L1A is limited to 7 years, right? And you're like, oh, but this I-140 could take a year to be approved. And then I would file for residency after it's approved. Well, that means I'm kind of screwed. I have to go home. So that would be an incentive to say, well, no, I'm going to file these both at the same time. So then I can stay because I have a pending adjustment case, even when my L expires, and I'll get work authorization pursuant to the pending residency case, which will also allow me to keep working. Right. So there is that incentive of if you're coming up on your 7-year max that you'd want to concurrently file. The second one is age outs, right? Because when a child turns 21, they're no longer part of the family. And so you would have this incentive sometimes to force to file the I-145. So sorry, to concurrently file or file the I-45, just to be 100% sure, right, that you're protecting that child so that they can adjust with the family. Again, it's not necessarily, you don't necessarily have to file the 485 because you can subtract the time the I-140 was pending from their age, and actually they're still protected. But some people, just to be safe, are like, no, I want to file the 485. We have a case like that just happened, right? Where we filed the I-140, both kids aged out, they got student visas, and then the I-140 was approved. Then usually what you do is you subtract the age, you subtract the time the I-140 was pending from their age, right? If that puts them under 21, then you have 1 year to file the 485, and they're still considered eligible. But some people don't want to risk that. They're just like, nah, I don't want to risk the I-140 pending stuff. I want to just file it all. So the I-45 is done. Plus, it can impact like, oh, I don't want them to have to change to F1. I'd rather just file the 45. They have a pending adjustment. They can stay. And they'll have work authorization and all of that. So it's usually capping out and aging out are two things that can push our hand into concurrently filing. And again, we always leave it up to the client. As long as the client's aware of the risk, we'll do it separate or we'll do it together. Andrew, any final thoughts on the EB-1C category?
I think one big thing that we haven't really talked about is the importance of understanding the difference between your immigrant petition and your non-immigrant petition. So, although there are a lot of similarities with the L, just because you're here on an approved L does not mean you automatically are going to get approved for this. USCIS is generally much stricter when they scrutinize an immigrant visa versus non-immigrant visas. So they can, push back even if you've been qualifying on an L for the last 7 years.
Yeah, that is very true. Two things to remember. One, um, they go to different service centers, right? So your L would go like to Vermont or to California, whereas like an I-140 would go like to the Texas service. It goes to different people, right? And obviously the residency folks tend to, knowing that that's kind of the, again, talking about our immigration hill, the top is that I-140. They know it's the most important critical thing. They tend to be more demanding, more exacting. And it's actually in their manual that says just because someone qualified for an L, it doesn't mean they qualify here. You have to, you know, fully evaluate it, because sometimes on the L, maybe they're willing to cut you some slack because they know it's temporary, right? You're going to have to come back and extend or eventually run out. So maybe they'll let you slide a little bit, right? But they're not going to on the I-140. So don't take the fact that, I mean, it'd be nice if I could just fill out my I-140 and then include my L approval notice and just say, here, right? I have an L. Let's not waste everyone's time re-adjudicating something that you guys already, which would kind of make sense. To say, why you guys are taking a year to do basic things? Maybe it's because you're adjudicating things you don't need to adjudicate. Um, but that's just not how it works right now, right? You're going to have to fully document ownership, the 1 year in the last 3 that you were a manager or executive, that the companies are doing business. Also, remember, anything going to USCIS has to be translated. So again, L's always have to have a lot of information from a foreign company, and all that. If it's, incorporating documents, if it's pay stubs, bank statements, it all has to be translated. So L's typically have a pretty, they can, depending on where you're from, can have a, significant cost of translations. Depending on, there are certain documents where we just do summary translations. Like if I have a lease agreement, I don't really need to translate all 30 pages. It's kind of pointless. We will sometimes just do summary translations of things like that. Or like a bank statement, don't really need to translate every single transaction. Sometimes we'll just do the first page where it shows like it says who the account holder is, the total deposits, total credits, so we can just see the amount of movement. And again, detailed job descriptions, not only for the beneficiary, but all their subordinates, org charts, employee lists, employee records. That is the key critical. Don't just say, well, I'm a manager. It's not enough. Or don't say, well, I have 100 reports. Cool. You have to document it and prove that they're not just line employees, and that you're not just a first line supervisor. Um, I've seen that happen. Guy had like 300 reports. He was like the factory manager, and they're like, well, how do we know that they're not all? It's like, no, dude, one dude's not going to manage 300 people. It's like impossible. Like there's mid-level supervisors and other managers. Don't take it for granted. USCIS will play dumb. So if you think you may be interested in the EB-1C, give us a call. Go to our website. You can book a consultation to talk with us about your case, and we can evaluate your options, whether it's the EB-1C or we have to go another route, whatever it may be. We'll figure out a solution for you. So reach out to us, contact us. Also, as always, download our app, Lawpilot GUARDIAN. You can find it for Android or iOS. You see the QR code here. Go to our website, download the app. Basic app is free. Got a lot of useful information regarding like knowing your rights and immigration updates. Obviously, we're adding in case management features too. So if you do end up having a case with us, we're starting to incorporate that. So it's going to be like your sort of full suite here of immigration support through an app that we're actively working on. But anyway, Andrew, it's fun as always. If you're interested in other categories, right, keep looking at our videos, the ones we already have, and we'll keep doing more until we've done them all. So we've covered all the bases, and we can help you find an immigration solution. Until then, thank you, and we'll see you later.